Hi class, welcome to chapter 6. We are talking about police and the Constitution. So what are the rules that bind us in law enforcement as related to the Constitution? So we're first going to talk about the four major sources that may provide probable cause. So the Fourth Amendment contains two critical legal concepts. One is the prohibition against unreasonable search and seizures, and two is the requirement of probable cause to issue a warrant. And there are a couple of concepts that we're going to go through when we talk about sources of probable cause. So, first off, probable cause is the burden that's required more than just a suspicion on a police officer's part. So the officer must know that there are facts and circumstances that would reasonably lead to the belief that an offense has been or is being committed. So probable cause cannot be retroactively applied. It must exist at the moment that a police officer takes a certain action. And there are several sources. The first one we're going to talk about is personal observation. And police officers may use their personal training, experience, and expertise to infer that probable cause from situations may not be obviously criminal. Information is where law enforcement officers receive some sort of information from victims, witnesses, informants, such as police bulletins or broadcasts. Evidence. In certain circumstances, police have probable cause for a search and seizure based on evidence in plain view, like there's a shotgun in plain view. An association is where, in some circumstances, the police see a person with a known criminal background in a place where criminal activity is openly taking place, and they have probable cause at that point to stop that person. So let's talk about this framework. We know that probable cause provides a framework that limits the situations in which officers can make arrests, but it also gives officers the freedom to act within that framework. So once an arrest is made, the arresting officer must provide to a judge that probable cause existed. So we're going to talk about a number of rules that need to be followed as we apply this to the probable cause that exists for an arrest. So the exclusionary rule is defined as a rule under which any evidence that is obtained in violation of the accused rights, as well as any evidence derived from illegally obtained evidence, will not be admissible in criminal court. So if there was a violation of the accused person's rights when the evidence was obtained, it will not be admissible in court. So any physical or verbal evidence police acquire by using illegally obtained evidence is known as fruit of the poisonous tree. Fruit of the poisonous tree. This is also inadmissible in court. So one of the implications of this rule, this exclusionary rule, is that it forces police to gather evidence in a proper manner. So if they follow appropriate procedures, they're more likely to be rewarded with a conviction. And if they are careless or abuse the rights of the suspect, they're unlikely to get a conviction. So another rule is called inevitable discovery. And critics of that exclusionary rule that we were just talking about maintain that regardless of statistics, the rule hampers the police's ability to gather evidence and causes prosecutors to release numerous suspects before their cases make it to court. There are several Supreme Court decisions that have mirrored that view and provided some exceptions to that exclusionary rule. The inevitable discovery exception is defined as the legal principle that illegally obtained evidence can be admissible in court, meaning it can be used in court, if the police were using lawful means would inevitably have discovered it. So if it was inevitable that they were going to discover that gun as soon as they got a search warrant to come in and do that, which was going to happen, that falls under the inevitable discovery exception. Now, the good faith exception is when we're talking about, again, how we get through that exclusionary rule in proper circumstances. So the scope of that exclusionary rule has further been diminished by two cases that had to do with faulty warrants. So in the first case, it was United States v. Leon. See if it shows you guys these. No, it doesn't. Okay, so United States v. Leon, 1984, the police seized evidence on authority of a search warrant that had been improperly issued by a judge. And in the second one was Arizona v. Evans in 1995, and there was a computer error, so a police officer detained a young man, or a man by the name of Isaac Evans, on this mistaken belief that he was subject to an arrest warrant. And as a result, the officer found a marijuana cigarette on his person and discovered a bag of marijuana when they searched the vehicle. In both of those cases, the court allowed the evidence to stand under a good faith exception to the exclusionary rule. And what this good faith exception tells us is it's a legal principle that evidence obtained with the use of a technically invalid search warrant is admissible during trial if the police acted in good faith, right? We can't help that computer glitch in Arizona v. Evans. We can't help that there was a computer glitch with that, which then said that Mr. Evans had to be detained, and upon detaining and arresting him, it was discovered that he had drugs, illegal drugs at the time, on him with his possession of marijuana. Okay, so let's talk about the different times that searches can be made without having a warrant. This is an important concept. The Fourth Amendment is super specific in forbidding unreasonable searches and seizures. If you learn one thing as you are going through law enforcement academy, they're going to hound this Fourth Amendment concept or the Fourth Amendment rules. So a real crucial concept in understanding the search and seizure law is privacy. A search is defined as the process by which the police examine a person or property to find some evidence that will be used to prove guilt in a criminal trial. And the recognized standard for a reasonable exception of privacy was established in Katz v. United States in 1967. And the Supreme Court held that the Fourth Amendment protects people, not places. So in his concurring opinion, Justice John Harlan Jr. said a two-pronged test for a person's expectation of privacy. So this two-pronged test basically states that a person must prove that he or she are expected to have privacy, and society must recognize that exception as reasonable. That is the two-pronged test set by the Supreme Court in that case. And despite the Katz ruling, simply taking steps to preserve one's privacy is not enough to protect against law enforcement intrusion. If a person is unreasonable or mistaken in expecting privacy, he or she may forfeit that expectation. And under the private search doctrine, law enforcement officers do not need a warrant to go through personal items that have already been searched by a third-party civilian. And the reasoning behind this doctrine is that once a private search has taken place, the owner of the searched items is no longer has that reasonable expectation of privacy. So, of course, we have warrants that we can get to search someone or something or someplace. And a search warrant is defined as a written order. It's based on probable cause and issued by a court, commanding that police officers or criminal investigators search a specific person, place, or property to obtain evidence. But before a judge or a magistrate can issue that search warrant, law enforcement officers must provide the following. They must have information that shows that there is probable cause, that the crime is going to be committed or has been committed. There also has to be specific information on the premises to be searched, the suspects to be found, and the illegal activities taking place on the premises. Or if we're going to be seizing items, we need to be able to have that detailed. And the purpose of a search warrant is really to establish before the search takes place that there is probable cause to search, and it really justifies infringing on the suspect's reasonable expectation of privacy. So there are some particular things that you guys should know about search warrants. The Fourth Amendment requires that a warrant describe with particularity the place to be searched and the things, either the people or the objects, to be seized. An affidavit is defined as a written statement of facts. It's confirmed by the oath or affirmation of the party making it, and it is made before a person having the authority to administer the oath. So when you write a search warrant and you go to have it signed by a judge, you are under oath and you are sworn in on your affidavit before the judge will sign it. The term, when we talk about search and seizure, it's important to understand that seizure is defined as the forcible taking of a person or a property in response to a violation of the law. So in general, the following four categories of items can be seized by the use of a search warrant. So items that result from the crime, that's going to maybe such as stolen goods, items that are inherently illegal for anybody to possess. So there can be certain exceptions, but narcotics or counterfeit currency. Items that can be called evidence of the crime, maybe bloodstained sneaker or a ski mask. And items used in committing the crime, such as an ice pick or a printing press used to make counterfeit bills. And the law gives law enforcement officers the ability to act reasonably during a search and seizure in the event of unforeseeable circumstances. So we need to talk about some different types of searches that occur without a warrant. So first and foremost, warrantless searches and seizures can be lawful when police are currently in the hot pursuit of a subject or when they search the bags of trash left at the curb. And because of the magnitude of smuggling activities in our border areas, airports, seaports, international boundaries, a warrant normally is not needed to search property in those such places. So the most frequent exception to the warrant requirement involves searches incidental to arrest. So this is a search that is made by an officer, and we know that as long as the original arrest was based on probable cause, so there was probable cause for the arrest, these searches incident to arrest are valid for two reasons. They are needed for a police officer to find and confiscate weapons that a suspect may be carrying. They also need to protect any evidence of the suspect's person from being destroyed. So law enforcement officers are, however, limited in the searches they can make during arrest. And those limits were established in the Supreme Court by the Supreme Court in Chimel v. California in 1969. And what the court said is they ruled that police may search an area within the suspect's immediate control to confiscate any weapons or evidence that the suspect could destroy. And the exact interpretation of the area within immediate control has been left to the individual courts. But in general, it has been taken to mean the area within the reach of the arrested person. All right, so then of course this brings us to another warrantless search, and that would be a consent search. And consent searches are the second most common type of warrantless search, and they take place when individuals voluntarily give law enforcement permission to search their person, home, or belongings. And the most relevant factors in determining whether consent is voluntary are as follows. They are the age, their intelligence level, their physical condition, if there's any coercive behavior by police, such as language used to request consent, and also the length of questioning by the location, where the location was and how long they are being questioned. So if the court finds that a person has been physically threatened or otherwise coerced into giving consent, the search is therefore invalid. And furthermore, the search must be a reasonable search. So when we search automobiles, we do have some case law that helps us with that. And in Carroll v. United States, 1925, the Supreme Court ruled that the law could distinguish among automobiles, homes, and persons in questions involving police searches. In the years since that decision in 1925, the court has established that the Fourth Amendment does not require police to obtain a warrant to search automobiles or other movable vehicles when they have probable cause to believe that that vehicle contains contraband or evidence of some sort of criminal activity. And the reason behind such leniency is really straightforward. Requiring a warrant to search an automobile places too heavy of a burden on police officers that are on that scene at that time. So warrantless searches are allowed only in two situations of a vehicle. Warrantless searches are allowed when the person being arrested is close enough to the car to grab or destroy evidence or maybe a weapon inside the vehicle, or if the arresting officer reasonably believes that the car contains evidence that is pertinent to the same crime for which that arrest took place. And police officers, however, still conduct warrantless searches of automobiles based on circumstances other than incidental to an arrest doctrine. And these circumstances include probable cause of criminal activity, consent from the driver, protective searches, just to look for weapons if police officers has a reasonable suspicion that such weapons exist. Now, as long as the officer has probable cause to believe that a traffic law has been broken, her or his true motivation for making a stop is irrelevant. So even if the police officer does not have a legally sufficient reason to search for evidence of a crime, such as maybe drug trafficking, the officer can use a minor traffic violation to pull over the car and investigate his or her hunch. So we will pause here and start back off with the plain view doctrine.